number 118, Clement v. Durban. Counsel?
Morning, Your Honor. Mayor Katz on behalf of the plaintiff. May it please the court. If I may, I'd like to reserve 2 minutes of rebuttal time.
2 minutes? You may.
In January of 2010, the plaintiff was a passenger in a car stopped at a red light.
So we're familiar with the facts, and I would ask you, I think you addressed it in a footnote somewhere in your brief, but why do you believe that the McBurney and Eggins tests don't apply here?
Eggins, I don't believe, well, let's deal with McBurney first. McBurney does apply. I mean, it's certainly the recent Supreme Court precedent. We don't contend it doesn't apply. It doesn't say anything that's dispositive here. With regard to the access to courts, the Supreme Court is very clear, first of all, that there is a right to access to courts. It's protected by the Privileges and Immunities Clauses. What it says is that the state may not discriminatorily burden that access to court in any substantial way. And there was no substantial burden in that case because there was no information asymmetry. Here, there is a substantial burden. My client is facing dismissal. My client is facing, at very least, a $500 indefinite loan that you will be compelled to.
Isn't the right to reasonable and adequate access, and isn't that available? If someone really can't afford it, they can seek to proceed without, establish their indigence or their inability to pay?
Through poor person status. But the question there is, why should she have to? She's being asked to do something on account of her non-residency that a resident similarly situated would not have to do. A non-resident would not have to go through that poor person status to demonstrate.
The thing is, residents and non-residents, there are distinctions made by government between them. They've been upheld by the Supreme Court. So the question is here, why isn't that type of framework that allows for those who can't afford it, for whom perhaps it's such a burden, why doesn't that satisfy the reasonable and adequate access to the courts?
I want to get back to the specific question, but I think the preliminary step, I think, needs to be clarified. It's true that the Supreme Court has upheld distinctions between residents and non-residents. That we don't question that. The question here is whether under Privileges and Immunities jurisprudence, there has to be first a substantial reason demonstrated by the state.
You're getting to the second prong of the test. First, you have to establish whether the access to the courts has been, and I think this is what Judge Rivera was getting at, has been unreasonably denied. Whether there has, we know that access to the courts is a fundamental concern, but the first question is, has there been a deprivation of that access?
Your Honor, I disagree, respectfully. Once you have a substantial right that's being, substantial right is not the right word, it's misused. Once you have a fundamental privilege and immunity, I think is the language that the Supreme Court uses, that's being infringed upon on the basis of residency, that there is discrimination on the basis of residency with regard to that privilege and immunity. De minimis or not, it makes no difference. We're talking about federalism here. That's ultimately the interest that's being injured.
So if we disagree with you, then is that the end of it? As to whether there is this first prong and that you have to meet it. You say you don't have to do that.
Just clarify the question. The first prong regarding whether we have to prove that there is some substantial access that's being lost?
Yes.
No, I don't think we lose. I mean, it's certainly a harder case. But the access that's being lost is that my client is facing dismissal. She, as I understand it, I don't have personal contact with her, but as I understand it, she's not going to or not able to pay. And she doesn't want to go through the process of proving indigency, which she doesn't have to.
Doesn't want to or can't?
Can't. I misspoke.
And why can't she?
Why can't she? I don't know her personal finances, but she says she can't afford it.
Oh, no, I'm sorry. Why can't she apply for poor person status?
It's humiliating. To go through that process, to put forth her personal, private financial data, she doesn't want to go through that process, and she shouldn't have to. It's a burden that's being placed on her by the state on account of her residency. And the upshot is that she's going to be denied access to the court on the basis of her going through that process. Let's back up. Let's say she fails.
There are other requirements that some people individually might find distressing or humiliating. But that doesn't provide them with a mechanism to avoid the requirements of the law. And I'm not really clear why her personal view that it would be humiliating to present information to allow a judge to determine whether or not she doesn't have to post the security is enough in this case. I'm not persuaded. Tell me why her personal view.
It's not a personal view. I mean, at least it's not dependent on a personal view. I think it's, first of all, objectively true that to go through that process, to lay out your financial data and have a court decide whether you're adequately poor, whether you're a poor person, I mean, that's the name of the statute uses, I think I think most people would find to be upsetting.
Well, what
Does
about
the
the-
state have an interest in protecting its residents?
Of course, but there's no interest here to be protected. The defendant's ability to execute a judgment, we're talking about $500. I mean, it's an incredibly small amount of money. The interest in ensuring
So it's de minimis, that's what you're saying?
it's more than de minimis. It has nothing to do with the purported interest, which the state hasn't even asserted. I mean, that's the point we haven't even mentioned. The state has never said this is the issue. Everyone's assuming that the issue is, well, because we want the defendants to be able to go and execute their judgments. The state never said that. If that is, in fact, the issue, why not plaintiffs? Why not interveners? I'm sorry, I forgot the question that I was answering.
Continue.
I wanted to come back to another point. That's unfortunate.
Have you thought at all about the Virginia case, the Virgin Islands case?
Sure.
Geraci versus Bentley?
Yes.
What's the status of it right now?
It is
As I
final.
understand, the Third Circuit had denied certiorari.
Correct. As far as I know, it's final. There's no petition for Supreme Court certiorari, as far as I know. The judgment stands.
I see.
And it's, as far as I know, the most recent, the only certainly state court of last resort to ever address this question head on, to ever deal with the question of whether or not securities for cost are constitutional in this context. And I think it's quite persuasive.
Can you describe what are these burdens that you say don't exist, the concern that's been raised in the decisions below about the burdens and the difficulties of trying to, excuse me, enforce a judgment against someone who is out of state? Discuss that, or enforce the costs, excuse me.
I remember now the question that I wanted to go back. Let me first answer that very briefly. In regard to whether or not there's a subjective burden here, there's no question that there is a constitutional right to privacy that's being infringed. So even if you disagree with me that there is an objective right to avoid humiliation.
That argument below?
Yes.
You made a right to privacy argument below?
We asserted that her privacy interests are being infringed on. We didn't make a claim under right of privacy per se. With regard to the interests of enforcement, you can enforce a judgment today between a coffee break, in the middle of a coffee break, sitting at your desk. I mean, there's nothing to it these days. You don't need counsel. You can do it electronically. If there's a hearing, which is unlikely, you can do it by telephone. I mean, it's very simple. Today, most states, 47 states, I think, have uniform rules, including New York. So the rules don't differ. We also have to keep in mind we're talking about differential burdens, right? If this case is in Queens, if I remember correctly. We're not talking about theoretically enforcing in Queens. We're talking about enforcing upstate, possibly quite far upstate in Buffalo.
Oh, my God, not Buffalo. That's
Sorry?
far? That's far, Buffalo, really? Oh,
My apologies, Your Honor.
You got to get out a little,
The point is not Buffalo. The point is it can be hundreds of miles away.
All right, don't worry.
So the difference between enforcing there and enforcing in New Jersey is negligible and might in fact be easier to enforce in New Jersey.
Thank you, counsel. Counsel?
Good afternoon. Mackenzie Fillo for the defendants. New York's security requirement does not violate the Privileges and Immunities Clause. Access to the courts, of course, is a fundamental right, but as Your Honors have mentioned, the access needs only be reasonable and adequate for the plaintiff to enforce her rights. And this law provides reasonable and adequate access to the courts. And
So what if the security for costs, the legislature decides we're going to make it $6,500 or $6,000 like the Virgin Islands, then what?
that would be a closer case, and especially if there were no poor person's exemption, no consideration of one's ability to pay. But here, as my colleague appears to concede, it's a minimal amount of money that we're talking about.
What about the burden of having to bear your financial circumstances and be humiliated?
Well, We dispute that being poor is humiliating, just as being rich is not superior, being poor is not humiliating. The courts have to have a reasonable way to know who is entitled to poor person relief. The application, you list your income and your expenses, and you swear that you can't.
Isn't there a more fundamental question? Because I don't think you can fairly argue that $500 is unreasonable. The question is whether or not it's equal justice. Isn't that really the question we should consider?
Well, so first he has to show a fundamental right, which I think your question seems to imply that it's not a serious
access to the
infringement
courts,
of
right.
that
Go
right.
ahead.
But even if you assume that it does infringe on a fundamental right, that infringement is justified by the additional difficulty of collecting from non-residents. They are not similarly situated, and so the state is free to treat them differently.
Is there an additional difficulty? Counsel seems to argue that there really isn't.
He does suggest that, but none of the cases or statutes he cites really hold up to that. I actually have been trying to figure out how to enforce a judgment in Georgia, and it's hard to even figure out. And the process of figuring it out, that is the burden even that a New York defendant is faced with when confronted with a meritless lawsuit from someone who lives in another state.
And if she challenged it in Georgia, doesn't the defendant have to go to Georgia, potentially?
In Georgia has a similar law,
Make
but
an appearance in Georgia?
I'm sorry, can you?
So if she had challenged it, if indeed there are costs that are imposed, and indeed, let's just say your clients, the defendants, seek to get the costs they want her to pay, right?
Yes, she could challenge it, exactly.
She could challenge it in
Yes.
Georgia, and then there'd have to be an appearance in Georgia or try to do something else, I don't know what.
Exactly. And of course, the city
So the
can't-
risk exists.
Certainly.
Is the risk enough in addition to some of the other burdens you've already described
Well, it is.
to satisfy the constitutional standard?
It does satisfy the constitutional standard. In fact, the Supreme Court has 3 times held up security for cost as the prime example of something that does not violate the Constitution. And
How recent was the last time?
I believe 1923.
The world has changed in almost a century, correct?
Certainly, but one of
Isn't
the...
that really his point? The world has changed. Those ideas, that justification no longer holds.
Well, one of those cases, Egan from 1920, the Supreme Court did cite positively in McBurney, just I think 5 years ago was McBurney. And certainly things have changed, but to suggest that there is literally no extra burden when you're trying to go enforce a judgment in another state, that is plainly false. We may one day get to the point where you can really just push a button and get the money, but we are not there yet.
Isn't part of the issue too with the costs? The costs are applied equally to all of the litigants, plaintiffs, defendants, residents, non-residents, but they're often of such a relatively small amount that the effort and expense of trying to enforce that, I mean, if you have $1 million judgment, obviously you're willing to go to certain, lengths to collect it, but is that relevant to our analysis?
Yes, that's certainly relevant. I mean, the cost might be $1,000, $1,500. A defendant who's holding a judgment that awards him that amount might try to figure out how to enforce it in Georgia and just say, I can't figure it out, this is too complicated, and then not get the money. And that's exactly the problem that this statute is intended to solve. And these
How do we know that?
Well, the legislative report says that, and I think the draft report that my colleague points out in his brief was in fact incorporated by reference into the final report. That page is in our compendium behind tab 1, it's the last page.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. I believe McBurney makes clear, it doesn't speak it out this way, but I think from reading the decision, it's very clear that there's 3 steps to the analysis. Step 1 is you determine whether there's a right that's being infringed that impacts privileges and immunities. Step 2 is you look to substantial burden, a substantial relationship. With regard to step 1, which is McBurney deals with 4 separate interests that were alleged to be infringed. Only the 4th of those, that right to access to information, the court goes into step 1, and there you see a whole discussion on history and policy and whether or not there's some kind of interest being infringed here in denying access to information. With regard to the other 3 prongs of the McBurney decision, the court never goes into any of that. And I hope this isn't a little too obtuse. It's hard to talk about it without the decision in front of me and the time I have, but when you look back at the decision, you'll see what I'm talking about. Then in the other 3, with regard to access to courts, for example, the Supreme Court never goes through any of that. The Supreme Court says we have a burden on access to courts, boom, substantial burden. That's the first question. And with regard to the substantial burden, we're talking about whether or not there's discrimination only. There's no question of whether or not the FOIA in particular affects a substantial burden. The question is only whether or not that access to information is being burdened. And the court said no, only because there's no information asymmetry. But if there would have been an information asymmetry, that would have been a burden on access to courts. The plaintiff is there. The plaintiff is able to walk into the courtroom and have her case heard. But the asymmetry, if there would have been one, and access to information is enough.
What if the security that had to be posted was $1? Would that make any difference?
I would want to know why the legislature did such a thing. It certainly smacks of discrimination, and the answer is no. If that's what's going on, if they're discriminating against non-residents, it's unconstitutional.
What if the reason why they made it $1 was that they didn't want to require people to have to go through an application for poor person status?
It doesn't serve any purpose. $1 doesn't do anything. And that very clearly, I think, smacks of discrimination. I want to get to the legislative report very briefly. It's a draft. It was a draft, the one that was incorporated into the compendium. Council says that it was incorporated into the final version. I don't recall seeing that. Even assuming that's true, we're talking about an advisory committee. We're not talking about the state legislature. There's no indication that the state legislature assented to it. There's no indication anywhere in the statute, from the face of the statute or any purpose section in the statute, that this is the purpose of the statute. You have the opinion of some lawyer writing a report, and that becomes the position of New York State. Frankly, I think that's quite silly. I mean, that's not the position of New York State, and it's not apparent from the statute anywhere.
Thank you, counsel.
Thank you.